Bandila natin muling nagwagayway, mga manggagawa ang siyang dahilan na mamahal at namumuhunan, nagtutulungan upang magtagumpay.
Pag-unlad natin ang ating tugon, pangkabuhayan dapat isulong. Kababayan kong handang tumulong, ngayon, bukas at habang panahon. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Maglilingkod, magtatanggol, lumilipad saan man naroon. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Laging isa-isip itong ating bansa.
Ang bandila natin muling nagwagayway, mga manggagawa ang siyang dahilan na mamahal at namumuhunan, nagtutulungan upang magtagumpay.
Pag-unlad natin ang ating tugon, pangkabuhayan dapat isulong. Kababayan kong handang tumulong, ngayon, bukas at habang panahon. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Maglilingkod, magtatanggol, lumilipad isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging isa-isip itong ating bansa. Laging isa-isip itong ating bansa.
Ang bandila natin muling nagwagayway, mga manggagawa ang siyang dahilan na mamahala at namumuhunan, nagtutulungan upang magtagumpay.
Pag-unlad natin ang ating tugon, pangkabuhayan dapat isulong. Kababayan kong handang tumulong, ngayon, bukas at habang panahon.
Tayo'y magkaisa sa diwa at gawa. Laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging isa-isip itong ating bansa. Maglilingkod, magtatanggol, lumilinaw saan man naroon. Tayo'y magkaisa sa diwa at gawa. Laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa
mga manggagawa ang siyang dahilan na mamahala at namumuhunan, nagtutulungan upang magtagumpay.
Pag-unlad natin ang ating tugon, pangkabuhayan dapat isulong. Kababayan kong handang tumulong, ngayon, bukas, at habang panahon.
Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Maglilingkod, magtatanggol, lumilinaw saan man naroon. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Laging isa-isip itong ating bansa.
Ang bandila natin muling nagbagayway, mga manggagawa ang siyang dahilan na mamahala at namumuhunan, nagtutulungan upang magtagumpay.
Pag-unlad natin ang ating tugon, pangkabuhayan dapat isulong. Kababayan kong handang tumulong, ngayon, bukas, at habang panahon.
Tayo'y magkaisa sa diwa at gawa, sa isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging sa isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging sa isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging sa isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging sa isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging sa isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging sa isip itong ating bansa. Laging sa isip itong ating bansa. Magkaisa sa diwa at gawa. Laging sa isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa. Laging sa isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa.
was only 12 when polio left his hands deformed and his right leg partially affected. Although the deadly disease made the life of young Axel Salise difficult, his disability never broke his spirit. The quiet barangay of Bailao in Mambaho, Camiguin is a witness to this exceptional resilience.
'Cause he ain't heavy, he's my brother. It's a long, long road.
Coming from a broken family, Axel had to fend for himself despite his disability. He kept his head held high and turned obstacles into opportunities, looking at every trial as a challenge.
Giagi kog tinda og kanang mga daos kamuti, tilaob nga mais. Gaangkato na mo na sa mga silingan nga mga farmers, walay puhunan. Nga mo nang baligyan ng buntag, eskwela dayon pagka alas 8, uli pagkahapon, tiwas og suroy, ang halin, iuli sa farmers, ang ginansya mo'y ako.
This innate sense of entrepreneurship would stay with Axel long after years in college. Life as an employee, however, only made him realize that he wanted to do more.
Sa sige na kong panarbaho, nakita na ko nga, wala, diha ang gigkataman. Maayo ang kong mga posisyon, okay ra po ang sweldo, pero mas patsada siya kung ikaw ang amo, ikaw ang magpadagan sa negosyo. That time, sige ko pangita kung saan ako, asa ko pangita og puhunan, kay lisod di kay ang puhunan, labi na sa amo nga case.
In 2012, as Axel was elected president of the Persons with Exceptional Reserve Skills Association, or PERSA, little did he know that his life was about to take a different direction.
One time, nakabasa ko og newspaper, nakita na ako nga nag-launch ang DOLE, muni nga mga program. Ato nakita na ako nga naay mga livelihood di ay. So gitanaw na ako kung asa ko nga mo fit. Ang DOLE na pasalamat ko nga gibak-apan gid ko. Tabangan nga ma-realize nga makapagawas gid ang proposal para nga mo come up mi sa usa ka proyekto nga mo nang nigawas na ko ang akong gi-apply ang PISONet.
Axel was more than determined to avail the DOLE Integrated Livelihood and Emergency Employment Program. And in 2014, through the Bureau of Workers with Special Concerns, DOLE-10 granted him 10,000 pesos for a PISONet unit, an arcade-style computer used as internet or gaming vending machine.
Maglisod kong compete sa akong mga silingan nga dunay mga computeran, tungod kay nakapanukad sila, daghan sila unit. So ako is isa lang. So ang gihimo nako is, ang akong profession is gigamit nako. Once nga mudawat ko mga encoding, inay nga mambak na sa printer. Prof. Fred, gina-edit na nako na, correct na nako ang grammar, ginapatsada nako, walay additional nga bayad.
Axel's excellent customer service won him loyal customers and attracted more patrons. He also teamed up with his wife, who has a background in hotel and restaurant management, in creating digital designs and layouts for event decorations, tarps, giveaways, and invitations. He further maximized one single PISONet unit by accepting research works. As his income steadily rose, Axel decided to expand with the purchase of 10 second-hand computer units and rent a space at the Mambaho Public Market. Thus, Axel Services Internet Cafe came to be. This was going to be the beginning of a more extensive list of new services, from computer troubleshooting, program installation, maintenance, and cleaning, to wireless security system services, from heat press printing to the retailing of computer accessories. With the considerable growth of Axel's business, it was time to bring in additional manpower.
Gikuha na ko kung mga pagumangkon, may ni-assess na ko. So, mas napalapad na mo ang among income, kay tulo na may magtrabaho, pero gipa-eskwela na ko sila. Hantod nga, gawas anang duha nga nag-back up na ko ang mga pagumangkon ako. Napay ko yung pagumangkon nga wala na ako nagpuyo. Nakahuman nag-eskwela, ngani, patsada sad ang ilang mga posisyon karon. Na sila sa Cagayan de Oro na katrabaho na.
Among them is Clarence, who finished a computer vocational course at TESDA thanks to Axel.
Ako kayo kung pasalamat sa iya, kay kung di tungod niya, wala ko karon bilib jud ko niya.
To this day, Axel continues to help his fellow PWDs. Jofel Aguirre, who once trained under him, recounts Axel's kindness.
Dito ko nag-OJT sa ila Sir Axel. And tungod sa kaayo po ni Sir Axel, siya gid mismo ang nag-develop sa akong kaibalos computer. Siya gid mismo ang nag-enhance ako sa mga paagi, sa mga teknik para mas mamaayo pa gyud ang akong paggamit sa computer. Igsuon gid ang iyang pagtagad namo. Bukas kayo ang iyang kasing-kasing pagtabang namo.
Today, Jofel works as a data encoder at the local government unit of Mahinog. Through his leadership as Puersa president, Axel lobbied for the release of 250,000 pesos in DOLE-X assistance, benefiting 24 PWDs and some senior citizens in October 2017. 24 sewing machines were made available for a sako bag and rag making project.
Paningkamot lang kita. Ang gobyerno daghan kayo og programa para sa katawhan. Pangalagaan nato dayon ang programa sa gobyerno, ang trust sa gobyerno ang gihatag nato. Kay dili na ko maabot ni ang naa nako karon kung wala ang gobyerno. Ang DOLE is Department of Labor and Employment, di ba? Pero sa ako, DOLE is Department of Living Enhancement, Life Enrichment.
He is my brother. 'Cause he ain't heavy, he's my brother.
Axel's story is a testament that we can all rise above difficulties in life and be an inspiration to others. To Axel, DOLE commends you, and may you continue to do more and be more.
'Cause he ain't heavy, he's my brother. It's a long, long road.
The 2019 profiling of child laborers by the Department of Labor and Employment in Northern Mindanao identified 13,221 engaged in hazardous forms of work. The top three nature of work in the region are farming, fishing, and domestic work. 21% have dropped out of school due to reasons such as cannot afford to go to school or to engage in paid or self-employment to augment family income. 1.5% have not been able to attend school.
Duhan ako na tuig wala nag-eskwela. Wala mi kang magtigsuon. Patay na si Papa o si Mama tuwa sa Cagayan nagtrabaho. Ang tuso na ako ni para akong mga manghod maka-eskwela. Ako na lang ang trabaho para nila.
Kada Sabado ug Domingo, usahay sa hapon human sa klase. Magdidang may uban akong mga manghod. Mga botilya ug lata ibalagya na mo sa junk shop. 20. Usahay 30 pesos. Dayon ihatag nako ni mama. Ipalit og bugas para na ami kaunon.
These stories represent the child laborers in Region 10. Because of the harsh reality of poverty, instead of attending school or going out to play, they work even under unforgiving conditions. This year, 2020, is the hardest of these child laborers and their families due to the pandemic. They risk more to be able to provide for their needs. However, with the strong linkages with our partner agencies, we are confident that we can help eliminate child labor in our country by 2025.
May bagong umagang parating.
The Department of Labor and Employment, Regional Office Number 10, continuously provides special protection to children from all forms of abuse, neglect, and exploitation, including child labor and its worst forms under Republic Act Number 9231.
Ang kinabukasan, nasa iyo ang pagkakataon na tagumpay. Tagumpay, may bagong umagang parating. May bagong umagang parating. Bagong umaga, bagong pag-asang parating.
Every child has the right to rest, play, and take part in cultural and creative activities. The right to be protected from doing work that is dangerous for their education, health, or development, more so from violence, abuse, and being neglected. Today, as we celebrate the World Day Against Child Labor amid COVID-19, let us protect children from child labor, now more than ever.
In the province of Bukidnon.
In the province of Cagayan.
In the city of Iligan and Lanao del Norte.
In the province of Misamis Occidental. In the province of Misamis Oriental.
In the city of Cagayan de Oro.
In northern Mindanao.
We stand against child labor.
Child Bank Build Ka Project supports 1 milyong Batang Malaya program.
Batang Malaya.
Batang Malaya.
Batang Malaya.
Batang Malaya. Batang Malaya.
Batang Malaya.
safety and health sa trabaho ay ating karapatan.
Ang safety and health sa trabaho ay ating responsibilidad.
Ang pagiging safe and healthy sa trabaho ay ating priority.
Ang safety at health sa trabaho ay para sa ating mga mahal sa buhay.
Para sa pamilya,
Dapat iwas sakit at disgrasya.
Pagligtas at malusog sa trabaho,
Pamilya ang panalo.
Nagkasakit o naaksidente ka sa work? Oh no! Buti na lang, andyan ang ECC. Ang ECC o Employees Compensation Commission ay ang government agency na nagpapatupad ng ECP o Employees Compensation Program. Ito ay karagdagang benefits in case ikaw ay magkasakit o maaksidente dahil sa work. Pero kahit may ECC, laging tatandaan na safety should still be your top priority. Kailan nga ba maaaring mag-file at mag-claim ng ECP benefits? Number 1, kung ikaw ay naaksidente sa workplace. Number 2, kung ikaw ay naaksidente habang nagtatrabaho. Number 3, kung ikaw ay naaksidente kahit wala ka sa workplace dahil sa utos ng boss mo. Number 4, kung ikaw ay naaksidente papunta o pauwi galing trabaho. Pwede ka mag-claim ng ECP benefits kung walang diversion sa ruta mo papunta o pauwi. Dapat ay bahay-work o work-bahay lang. Number 5, pwede ka rin mag-claim ng ECP benefits kung ikaw ay naaksidente habang sakay ng company vehicle. Number 6, counted pa rin kung ikaw ay naaksidente sa activities ng company. Halimbawa, sa mga company team building at sports fest. At last but not the least, kung ikaw ay nakaranas ng assault habang ginagampanan mo ang trabaho mo. Kapag ikaw naman ay nagkasakit dahil sa trabaho, pwede ka mag-claim ng ECP benefits kung ang conditions of compensability ay nasatisfied mo base sa listahan ng occupational and work-related diseases. Pag ang sakit mo ay di kasama sa listahan, pwede pa rin ito maging compensable sa ilalim ng tinatawag natin na increased risk theory. Una, kung ang working conditions ay may health risks na nagiging sanhi ng sakit. Pangalawa, kung ang sakit ay nakuha mo dahil exposed ka sa mga health risks na ito. At pangatlo, kung nagkasakit ka kahit na sinusunod mo naman ang safety measures and precaution ng kumpanya. Samantala, meron naman tayong tinatawag na excepting circumstance o yung mga pagkakataon na hindi ka pwedeng mag-claim ng EC benefits. Kung ikaw ay lasing o lango sa alak o drugs habang nagtatrabaho at naaksidente ka. No yan. Hindi ka rin pwedeng mag-claim ng ECP kung ikaw ay nagpabaya o notoriously negligent ka kaya ka naaksidente o nagkasakit. Halimbawa ay ang hindi pagsunod sa safety precautions ng kumpanya o hindi pagsuot ng protective gear. Hindi rin valid ang claim kung sinasadya mong saktan ang sarili mo o ang iba na naging sanhi ng aksidente o sakit. Bad yun! Laging tandaan na safety should always be your first priority kahit saan, kahit kailan, kahit sa trabaho. Kapag aksidente di maiwasan, don't worry! Andyan ang ECC to help you! For more information, pumunta lang sa pinakamalapit na ECC office sa inyong lugar. Remember, kahit may ECC, lagi ka pa rin mag-ingat ha!
The Philippines is a home for more than 900,000 business enterprises and almost 8 million skilled and talented workers. To help these enterprises become competitive while ensuring the protection of workers' rights and benefits, the National Wages and Productivity Commission and the 17 regional tripartite wages and productivity boards recreated in July 1989 the Republic Act 6727 or the Wage Rationalization Act. The NWPC at the national level acts as an advisory body to the President and Congress on all matters pertaining to wages, incomes, and productivity. The RTWPBs, on the other hand, are mandated to fix minimum wages from private sector and promote productivity and improvement at the regional, industry, and enterprise levels pursuant to policies and guidelines issued by the NWPC. At the same time, the NWPC and the RTWPBs are also mandated under Republic Act 6971 or Productivity Incentives Act to provide technical assistance to enterprises and the development and implementation of productivity improvement programs. Our vision: justly remunerated and productive Filipino workforce in globally competitive enterprises. Our mission: set minimum wage that protects workers' welfare, promote enterprise and workers' productivity. To realize the vision and mission, the NWPC and RTWPBs are implementing the following programs. First is a policy shift to adapt the two-tiered wage system, which provides for the mandatory minimum wage and voluntary productivity-based pay. The TTWS framework defines the space from the minimum wages as above poverty threshold but lower than average wage. While for the second tier, the NWPC encourages and enables workers and enterprises to implement productivity improvement and performance incentivizing scheme. To support these, the NWPC and the 17 regional boards nationwide are implementing the Productivity Toolbox, a ladderized, needs-based approach to productivity improvement for MSMEs. It is a package of training and technical assistance designed to help MSMEs grow, expand, and become viable enterprises, creating more employment opportunities and additional income for our workers. Beneficiaries of the training programs can join the Productivity Olympics, a biennial national competition of the best productivity improvement practices from micro, small, and medium enterprises. To popularize these programs and educate clients on wages and productivity, the NWPC and RTWPBs are implementing a rigorous public awareness campaign to the Kaalaman sa Kita at Kakayanan program, which includes public information assistance, development and dissemination of IEC materials, learning sessions, lectures, seminars, and mass media campaign. As the needs of the enterprises and workers change, the NWPC and RTWPBs are also continually promoting programs and policies on wages, incomes, and productivity that are to help drive the economic growth and improve productivity and competitiveness of the country.
Bandila natin muling nagwagayway, mga manggagawa ang siyang dahilan, namamahala at namumuhunan, nagtutulungan upang magtagumpay.
Pag-unlad natin ang ating tugon, pangkabuhayan na pati sulong, kababayan kong handang tumulong, ngayon, bukas, at habang panahon. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Tayo'y magkaisa sa diwa at gawa, laging isa-isip itong ating bansa. Maglilingkod, magtatanggol, lumilipad saan man naroon. Tayo'y magkaisa sa diwa at gawa. ayusin itong ating bansa.
A pleasant morning to all. The Department of Labor and Employment, namely the Regional Reconciliation and Mediation Board 10, the Occupational Safety and Health Center 10, Employees Compensation Commission 10, and Regional Tripartite Wages and Productivity Board, give our utmost pleasure to welcome all of you who are attending today's session. We are now in our second series with the theme Intensity 10, Workers' Protection Strengthened, Industrial Peace Ensured, Welfare Programs Enhanced. So today marks the first of the 5 sessions of this webinar series, which will span over the next 4 Fridays of October. My name is Rebecca Mary Justine Camugao. I am the Planning Officer of DOLE Region 10, and I will be your moderator for today. The aim of our government through this department is that as you complete our sessions, you will be able to increase your awareness on workers' and employers' rights and responsibilities, work ethics, values, and skills to contribute in fostering a more cooperative labor management relations and the attainment of decent and productive work. This is reflective of the 5 sessions in our second webinar series. Next Friday, that is on October 2, 2020, Usapang 2Ps, Pasahod and Productivity will be discussed by Attorney Virgel Walag, the Board Secretary of the RTWPB 10. On October 9, a representative from the Central Office of Bangko Sentral ng Pilipinas will be explaining the DOLE Labor Advisory 26-2020, or the payment of wages and other monetary benefits through transaction accounts. The topic on psychosocial resilience in the workplace in the period of pandemic will be given to us by our returning resource speaker, Dr. Genaro Hapos. He is also the founder and president of the Philippine Association of Institutions for Research. So this will be on October 16. The last topic in this webinar series will be on October 23 and will be presented by social media engineer, Miss Anne Christine Peña Redondo. This will be all about breaking barriers, skills, and tips to navigate the digitized workplace. Now, for this morning session, we will focus on the rules on termination of employment. Our attendees today are composed of employers, workers, and workers' organizations from our private sector. Before we start, we would like to remind all participants that questions will be answered during the open forum after our topic has been presented for this morning. All participants are requested to fill out the feedback form with the link provided in your chat box. Kindly fill this form out with your full name as per your registration details, as this will be our basis for your e-certificate of participation. We would like to stress that in your feedback form, the name that you would like to be on your e-certificate of participation will be the name on your feedback form. The certificate will be emailed to you through the email address you provided upon registration to this webinar session. Your feedback will greatly help us improve our future webinar sessions. Now, at this point, to officially welcome us all, let me give you the Regional Director of the Department of Labor and Employment Region 10, Attorney Geoffrey M. Condeo.
Okay, thank you very much, Justin. We're just fixing the echo here. Okay, thank you very much. Hello, everyone. A pleasant good morning to all of you, our dear friends of the Department of Labor and Employment. Ladies and gentlemen, I am pleased to welcome you to the second series of our webinars. And of course, we thank you for your support ever since we have run the series of webinars brought to you, of course, by the Convergence team of the team of agencies under the Department of Labor and Employment, headed, of course, by the Regional Tripartite Wages and Productivity Board, led by our Director, Attorney Ligaya G. Lumbay, Regional Tripartite Wages and National Conciliation. That's Attorney G. Lumbay heads the National Conciliation and Mediation Board in Region 10. And of course, we have also under our team the Regional Tripartite Wages and Productivity Board, and together, of course, with our Board Secretary, Attorney Virgel Walag. And of course, we also have with us our Occupational Safety and Health Center in Region 10, headed by Lisel. And we also have the Employees Compensation Commission office here in our region. You can visit them, headed, of course, by Ms. Stella and Mr. Kel. No? And we are very pleased that together with our agency partners under the DOLE, of course, from the Department of Labor and Employment, this series of webinars would not have been possible without, of course, the support of our technical division. We have our technical people backing us, led by Director J.V. Vasallo and Mr. Glenford Labial, and together with a very talented and support staff that are with us from our first series with the theme COVID-19 in the workplace, combating challenges and discovering opportunities. So this second series, we also have 5 sessions, but our technical team has chosen the theme Intensity 10, Workers' Protection Strengthened, Industrial Peace Ensured, and Welfare Program Enhanced. Our first topic for today, as announced already by Ms. Justine earlier, is on the rules of termination. And we are glad that all of you have suggested during the first run of our webinar. We asked you to provide us or to provide a suggestion or recommendation on what topics would you like us to discuss, no? And so the rules on termination came on top. And of course, this is not surprising because this also mirrors the issues and concerns that we receive in our own offices or work from our walk-in clients. And hence, we decided that maybe this topic is really apt at this time, considering, of course, the uncertainty that not only our employers, but also our workers are experiencing. We are in very, very interesting and so challenging times with a lot of companies adopting temporary closures, flexible work arrangements, and any other alternative work arrangements that are allowed just, of course, to survive and help preserve employment. But there also comes a time, no, when our employers really decide either to temporarily or to permanently shut down, displacing all workers, or just adopt retrenchment and other retrenchment measures, no, to save the business. So they have to let go of some of their workers. So in these very painful decisions by our companies, undoubtedly it affects the lives, no, not only the livelihood, but of the person being displaced, but most especially, of course, the families that they support and they feed, no, when they are cut off from their work and from their income. And so it is very important that we know, no, not only for our employers, but also for our workers, on what are the rules that governs, no, decisions like this on termination of the employment status or of the employment of an individual worker. And so we would have actually wanted to invite our friends from the National Labor Relations Commission, but of course we understand that the NLRC, being the final arbiter of issues on termination of employment or the legalities of dismissal, validity of decisions of employers to dismiss or terminate the employment of the workers. But of course, we also understand that the NLRC would be put or might be put in a very sensitive and situation when they will be asked by you by us, by our audience, on very specific questions, and it might compromise no, decisions that that are pending before them or might come before them on similar issues. No, so today we decided that we in the DOLE would be discussing this topic, and of course, no less than our lawyer in our office, our Mediator-Arbiter Attorney Amor Bajarla, is chosen to provide us and guide us through the rules and the laws on termination, so that we will have a common understanding, no? On how do we do things right, and on of course so that we will lessen the impact, no, the negative impacts of termination, so that if we will have a common understanding, then maybe there will be less issues, less tension, less stress, no, amongst us, not only from the workers, from the employers, but also from the government, like the Department of Labor, NLRC, and all the attached agencies of the Department of Labor. So because this topic was chosen by you, we hope that you interact with us, and there is a question and answer portion at the end of the presentation, and we hope that you will enrich this social dialogue, so that maybe with your suggestions, recommendations, no, we could further and also enhance on how the government could maybe deliver better service to all of you. So thank you very much for your interest. Again, we welcome you to the second series of the webinars brought to you by the DOLE team of agencies. We call ourselves the Convergence team. And so we hope that you will be with us during the 5 sessions. And today is the start of the first session. And we will be posting, as announced already by our moderator, we will post again during this, the duration of this webinar, the schedules of the next sessions. And we hope we will see you again for our learning sessions and interaction. Thank you very much. Ug maayong buntag sa atong tanan.
Thank you, RD for your warm message. At this point, we would like to remind our participants to please mute your microphones, and then if possible, you can also open your videos. So all questions will be answered during the open forum. There will be a time for your questions, where your questions will be answered. And now for our topic for today's session, on rules on termination of employment, may I give you the Mediator-Arbiter of the Department of Labor and Employment, Region 10, Attorney Amor Condeo T. Bajarla. Attorney?
So, good morning, everyone. Welcome to webinar series 2. No, as your resource speaker, I'll be discussing the law on termination, as well as some relevant principles and cases decided by the Supreme Court in relation to termination. To start off, let me give you a brief background or history on the Philippine settings law on termination. The earliest law on termination was actually Article 302 of the Code of Commerce, which provided for the payment of the so-called mesada. The old law also provided that in cases where the employment contract does not provide a fixed period, any of the parties may terminate the same, provided that the other party is informed 1 month prior to termination. Later on, with the effectivity of the new civil code, Article 302 was repealed along with the other provisions of the said code on agency. Subsequently, Congress enacted Republic Act number 1052, so which is otherwise known as the Termination Pay Law. This was later on amended by Republic Act 1787, which basically took effect sometime on June 1957. So it was enacted for the purpose of giving the employer an opportunity to secure a replacement and the employee a similar opportunity to find another employment. This enactment also gave aid, which is termed as termination pay, to the laborers who are terminated without due notice, no, in order for them to have a means of supporting himself as well as his family. Well, at present, our law on termination requires that an employer can terminate an employee only for a valid and just cause, which must be supported by substantial evidence. So our law on termination is found in Title 1, Book 6 of the Labor Code of the Philippines. With our law on termination, the state strikes a balance between the exercise of the management of its prerogative to protect its legitimate interests and in relation to the right to security of tenure of the workers. So what are the legal basis of our law on termination? It is grounded no less than by our Constitution, particularly Article 13, Section 3, no, which pertains to the social justice and human rights of the 1987 Constitution. So the Constitution specifically provides that the state shall guarantee the right of all workers to security of tenure. It is also embodied under Article 279 of our Labor Code that in case of regular employment, the employer shall not terminate the services of an employee except for a just cause or authorized causes. While Article 279 speaks of regular employment, it must be noted, however, that the security of tenure does not apply only to regular employees. No, in fact, probationary employees, project employees, or fixed-term employees are also entitled to security of tenure, but to a limited extent. For instance, for probationary employees, they are entitled to the security of tenure insofar as the probationary period is concerned. As to the fixed-term employment, they are entitled to security of tenure for the duration of the contract. So they cannot be indiscriminately terminated without observance of procedural due process as well as the substantive due process. Now, what is the coverage of our law on termination? So it is provided for under the Labor Code that it applies to all establishments or undertaking, whether for profit or not. So it also applies to religious institutions. The only primordial consideration in order for law on termination to apply is the presence of employer-employee relationship. So without which the law on termination does not apply. So we go now to the concept of termination. So termination is actually a very broad term, or a comprehensive term, which is used to describe dismissal or layoff or both. Next slide. So one of the prerogatives of the management or the employer to protect its interest is the power of dismissal. Dismissal is the discharge of an employee or a termination of employment in private or public capacity at the instance of the employer. So dismissal mentions of discharge, no? And discharge in the context of dismissal, it takes place when a clear intention is manifested by the employer to dispense with the services of the employee. So there must be some declaration on the part of the employer that the services of its employee will no longer be accepted. So the next term is layoff. So layoff, as defined, is a termination initiated by the employer, although it is different from dismissal because it is merely temporary, no? Since it is without prejudice to the recall or reinstatement of a worker who has been temporarily separated. Examples of causes of layoff, no? For example, a particular establishment encounters breakdown of machinery, or they have their machinery for repairs, business reverses, lack of raw materials, and among others. The concept of layoff is actually, this is contemplated also in under Article 301 of the Labor Code, no? Basically, Article 301 of the Labor Code provides when employment is deemed not terminated. So the bona fide suspension of the operation of business for a period not exceeding 6 months, as well as the fulfillment by the employee of a military or civic duty will not terminate employment. So within 6 months from the temporary suspension, the employees who are temporarily laid off must be reinstated or must be recalled to work. Otherwise, it may amount to illegal constructive dismissal. So the requirements under Article 301, unlike in the authorized causes for as provided for under the Labor Code, it does not require 1 month notice to the Department of Labor and Employment. Moreover, it is imperative that the employer must also prove, no, the existence of a clear and compelling economic reason for the temporary shutdown of its business, and that because of the shutdown, there were no available posts by which the affected employees may be assigned. Of course, failure to prove the compelling reason or justifying reason for the temporary shutdown, it would render the validity of the suspension questionable. In relation sa layoff pod, we also have to familiarize ourselves with kanang floating status, no, as provided for under DO-174, as well as the floating status of security guards. Well, unlike in Department Order 2174, the security guards may be placed on a floating status for a period not exceeding 6 months, while in DO-174, it is only 3 months. So if there's no, the employees cannot be recalled under DO-174, then they have to be paid their respective separation pay. Next, please. So another type of termination is or separation is quitting or resignation, no? It is one which is voluntarily initiated by the employee for personal reasons of his own, or perhaps to obtain a better job, or dissatisfaction with terms and conditions of employment. It also is falls within termination of employment. However, it must be emphasized that in a resignation, it must be voluntarily done by the employee, because if it is a forced one, it will amount to illegal constructive dismissal. Next. So now we go to the requirements before an employer may terminate the services of an employee. Of course, there must be just or authorized causes, and there must be observance of due process. I would also like to discuss some principles, no, on dismissal, particularly kanang the totality of the infractions rule. Under this principle, the previous similar infractions committed by a particular employee may be considered by the management in the position of a harsher penalty. So the only condition is that the similar infractions, the infractions committed must be similar to that of previously committed by the employee. Also, we have to understand that even the Supreme Court, no, holds that dismissal is too harsh a penalty. So if there are less punitive disciplinary action that may be undertaken by the management, then it must be resorted to, and dismissal must be considered as a last resort. Next. So Article 297 provides for the just causes, no, for termination. These are serious misconduct, willful disobedience, gross and habitual neglect of duties, fraud or willful breach of trust and confidence, as well as commission of a crime or offense by the employee against the employer or his representative. Of course, the catch-all provision, other causes analogous to the foregoing. So let's discuss first serious misconduct. So serious misconduct, as defined by law, is improper or wrongful conduct. No, it is the transgression of some definite or established rule of action. So it is dereliction of duty and implies wrongful intent and not mere injudgment. The misconduct, however serious, must be, of course, in connection with the employee's work in order for it to constitute a just cause for his dismissal. It must not be trivial, no, from the word serious. Examples of which are repeated absences without leave, no, as decided by the Supreme Court. So falsification of employment records, destroying properties of the company, as well even fighting within the company premises and challenging its co-employees to a fight. No, these are considered serious misconduct, which may be a ground for dismissal of the concerned employees. So what are the requirements, no, in order to effectuate a valid dismissal on the ground of serious misconduct? First, there must be misconduct, of course. Then such misconduct must be of such grave and aggravated character. So as I've stated earlier, it must not be trivial. It must also relate to the performance of the employee's duties. And lastly, there must be showing that the employee becomes unfit to continue working for the employer. So I would just like to emphasize that serious misconduct must relate to the performance of the employee's duties, because in one case involving theft, no, of property of a co-employee, the Supreme Court ruled that the theft committed against a co-employee and not against the management does not constitute serious misconduct because it does not relate to the performance of the employee's duties. However, such employee cannot be exonerated from the penalty of dismissal, no, because there is a catch-all provision, as I've emphasized earlier, katong analogous to the foregoing, which will be extensively discussed later. So the next ground for just cause is willful disobedience, no. So as defined by the Supreme Court in the case of Family Planning Organization of the Philippines versus NLRC, it is the refusal to do an act or obey a reasonable and lawful order of the employer or his representative and sufficiently known to the employees and in connection with the duties which the employee has engaged to discharge. So for it to be considered as willful disobedience, it must be intentional and wrongful, no? So not all disobedience would constitute a ground for termination. Take for instance the case decided by the Supreme Court involving an employee who was terminated because he refused to heed to the employer's directive to issue a check. No, the reason for the employee why he did not immediately issue the check is because of the insufficiency of funds of the company. Now, when the employee filed a case for illegal dismissal and it reached the Supreme Court ruled that it cannot be considered as willful disobedience because the actuation undertaken by the employee in not immediately acceding to the directive of his employer is not wrongful per se, no? Because in fact, the purpose why the employee failed or did not heed to the issuance of the check because the company may be susceptible to the filing of estafa or BP22. So the Supreme Court did not affirm the contention of the management to dismiss the employee. So what are the other examples, no, of willful disobedience as decided by the Supreme Court? First, unauthorized use of company vehicles. So also refusal to obey a lawful order of transfer, as well as non-compliance with company policies. Next. So what are the grounds? No, what are the requirements? No, first there must be disobedience or insubordination. The disobedience or insubordination must be willful or intentional. So it must be characterized by a wrongful and perverse attitude. Also, the order violated must be reasonable, lawful, and made known to the employee. And the order must pertain to the duties which he had been engaged to discharge. No? As to the last requisite, of course, you cannot expect a janitor to comply with the directive of the employer to prepare financial statements, no? Because if the janitor or the employee fails to comply with such directive, then it cannot be constitute willful disobedience because it does not pertain to the duties for which he is hired, no? So, depending on the circumstances and the presence of the requisites, ground for willful disobedience or insubordination cannot always be invoked in the absence of any one of the requisites as provided for under the law. Next. So another ground is gross and habitual neglect of duties. So as decided by the Supreme Court, gross neglect means absence of that diligence that an ordinarily prudent man would use in his own affairs. So the neglect of duties must not only be gross, but also it must be habitual. The ordinary prudent diligence required is that of the diligence of a good father of the family. So it does not require the extraordinary diligence for gross and habitual neglect of duties to be invoked by the employer. Also, gross negligence, as discussed by the Supreme Court, it connotes want of care in the performance of one's duties. No? And habitual neglect implies repeated failure to perform one's duties for a period of time. So, example of habitual neglect of duties, which is repeated, no? Numerous absences or tardiness without justifiable reason or excuse. Of course, it constitutes a gross and habitual neglect of duties. Meanwhile, a single tardiness or absence, no, can hardly be considered as gross and habitual neglect of duties to warrant dismissal of an erring employee. Next, please. So what are the requisites or the grounds for the requirement in order to invoke gross and habitual neglect of duties? First, there must be neglect of duty, and the neglect of duty must be gross and habitual in character. Examples, kanang mga habitual absenteeism without leave, sleeping on the job, including abandonment, no, which is a common ground for habitual neglect, gross and habitual neglect of duty, abandonment. So let me discuss this next, please. Kanang abandonment of work. So abandonment of work is it occurs when there is a deliberate and unjustified refusal of an employee to resume his employment. So it must be deliberate and unjustified, no? And of course, there are factors to consider in order to arrive at a conclusion whether there is abandonment. Of course, it includes that the failure to report for work or absence without valid or justifiable reason. Second, there is a clear intention on the part of the employee to sever the employment relationship. No, the second requirement being the more determinative factor, which is manifested by overt acts, from which it may be deduced that an employee has no more intention to work. So the intent to discontinue the employment must be shown by clear proof that it was deliberate and unjustified. So also the Supreme Court ruled in numerous cases, no, when an employee who has been dismissed for abandonment of work, but who immediately questions his dismissal and files a case, no, for illegal dismissal, it may be considered as an indication that in fact there is indeed no intention on the part of the employee to sever his employment relationship. So next, the next is fraud or willful breach of trust. No? So fraud has been defined as by jurisprudence as an act, omission, or concealment which involves a breach of legal duty, trust, or confidence reposed upon by the employer to his employees, which is injurious to another. Well, to constitute a willful breach of trust or fraud, the fraud must be committed against the employer or representative of the employee and in connection with the employee's work. So in addition, it must be, the breach must be willful, no? Or it must be done intentionally, knowingly, and purposely without justifiable excuse. Specific examples of which are when the supervisor initiates an illegal strike or boycott, or there's a failure of a cashier to account for the shortage of company funds, or there's an attempt on the part of the employee to cover up pilferage of company properties, as well as stealing of company property. They are all grounds for dismissal on the basis of fraud or willful breach of trust. Next. So what are the requirements, no, for the ground for the dismissal on the ground of fraud or willful breach of trust? So there must be an act, omission, or concealment, and that it involves a breach of legal duty, trust, or confidence justly reposed upon by the employer to the erring employee. It must also be committed against the employer or his representative, and that it must be in connection with the employee's work. So it is very important that to invoke this particular ground, we must understand that the fraud or breach of trust must be in connection with the employee's discharge of his functions. So there is also another ground for dismissal, which relates to willful breach of trust, kaning loss of confidence. No, under this ground, this cannot be used indiscriminately by the employer. No, because there are requisites. First, there must be an act, omission, or concealment, and it would justify the loss of trust and confidence of the employee, and the employee concerned must be holding a position of trust and confidence. The loss of trust and confidence should not be simulated. So the management cannot pretend that there is loss of trust and confidence simply to ease out a particular employee. It should not be used also for causes which are improper, illegal, or unjustified. And it must be genuine and not a mere afterthought to justify an earlier action taken in bad faith. No, not all employees actually occupy trust and confidence in the context of this ground, no, because only those employees which who by the nature of their functions, for example, managerial employees, are entrusted with delicate matters on the company, as well as those non-managerial or supervisory employees who are entrusted with a substantial amount of money or property. So before this can be invoked, the employer must first establish that the employee concerned occupies the position of trust and confidence. So next, no. So commission of a crime by the employee. So this ground is anchored on the act of the management for self-preservation, no. This is related to self-defense. Of course, there are requisites. First, there must be an act or omission which is punishable or prohibited by law, and the act or omission is committed by the employee against the person of the employer, any immediate member of his family, or his duly authorized representative. So the last just cause, analogous causes. This is a catch-all provision, as I've emphasized earlier. The Supreme Court held that in order for it to be considered as analogous to the just causes mentioned earlier, it must be susceptible of comparison with those grounds mentioned, no, either in general, as in some specific detail, or has close relationship with the just causes I mentioned earlier. And under section 5.2 of DO 147, it expressly provides the valid the requirements for it to be invoked, no. There must be an act or omission similar to those specified under just causes, and the act or omission must be voluntary or willful on the part of the employees. A specific example of which, violation of company rules, no. These cases are decided by the Supreme Court. A violation of company rules and regulations, such as the no smoking or no sleeping rule or the liquor ban committed by the employee. So a second is theft committed against a co-employee. As I mentioned earlier, it is not a ground for serious misconduct, no, per se. However, it can be considered as a just ground for termination because it is analogous to serious misconduct, no. Because while it is not work related, it is willful, which attests to the employee's moral depravity. Also, analogous to serious misconduct is immorality or drunkenness or fighting inside the company premises. It also constitutes analogous as analogous cases. As to sexual harassment committed by a manager, it constitutes it is analogous to a fraud or willful breach of trust. And as to gross efficiency, it is analogous to gross and habitual neglect of duties. Next, please. So we now go to authorized causes. No? So the grounds as provided for under the labor code includes installation of labor-saving devices, redundancy, retrenchment to prevent losses, closing or cessation of company, as well as disease. No, unlike in just causes, the authorized causes is impelled or it is motivated by the exercise of management prerogative, and it is not dependent on a particular act or omission of the employee, which is inimical to the interest of the company, unlike in just causes. It contemplates the installation of machinery to effect economy and efficiency in the method of production. So because of the advancement of technology, it is the prerogative of the management to resort to installation of labor-saving devices in order to streamline its operations that would be cost efficient and that would be more productive to the enterprise. So what are the requirements or the requisites for a valid termination on the ground of installation of labor-saving device? First, there must be introduction of machinery, equipment, or other devices. Also, the introduction must be done in good faith. Thirdly, the purpose of such introduction must be valid, which is to save cost, enhance efficiency, and the consequent termination of the employment of those affected. And there must be a fair and reasonable criteria in selecting the employees to be terminated. So the employer, in resorting to these authorized cause, cannot just indiscriminately terminate its employees without considering the fair and reasonable criteria. This may be shown by, for example, sa status of workers, efficiency, seniority, as well as physical fitness or age, among others. Now, let me emphasize that good faith is always presumed. So if the employees would question the legality or the validity of the action undertaken by the management in coming up with termination based on the authorized causes, it must be established by the employee that it was undertaken in bad faith. So next, please. So we now go to redundancy. So case law explained that redundancy exists when the services of an employee are in excess of what is reasonably demanded by the actual requirements of the enterprise. So in short, the position is redundant when it is superfluous, or there is an excess of what is actually needed in a particular enterprise for efficiency and economy. Redundancy may result because of overhiring of workers, or there's a decreased volume of business, or there's a dropping of a particular product line. The rationale behind redundancy is that the employer is not mandated to keep under its employ more employees than which are necessary for the operation of his or her business. Next. So what are the requirements, or the requisites for redundancy? There must be superfluous positions or the service employees, and such positions or services are in excess of what is reasonably by the actual requirements of the enterprise. And also, this is very important. There must be in good redundant position. Also, there must be fair and reasonable criteria in selecting the employees to be terminated, as well as an adequate proof of redundancy. To raise or invoke redundancy as a ground for termination, there must be adequate proof, no, such as new staffing pattern or the feasibility studies or proposal on the viability of the newly created positions, job description, and the approval by the management of the restructuring. So there's must also be a 1-month written notice, no, to be given to the concerned employees, as well as the Department of Labor and Employment. And there must be separation pay equivalent to at least 1 month pay per every year of service. Next. We now go to retrenchment. So as explained by jurisprudence, retrenchment is the severance of employment which is resorted to by the management because of periods of business recession, industrial depression, or seasonal fluctuations, or during lulls caused by lack of orders, shortage of materials, or conversion of the plant to a new production program, among others, for efficient machinery or of automation. So it is an act of the employer dismissing employees because of losses in the operation of the business, a lack of work, and considerable reduction in the volume of business. So retrenchment is a termination of employment initiated by the employer because of economic or business reverses, no? Take for example, kaning COVID karon, which is very trying times, not only for the workers but the management as well. And in contrast with redundancy, retrenchment is a cost-cutting measure, while redundancy results from mere superfluity of certain positions without need of incurring losses on the part of the management. So what are the requisites or requirements? So the retrenchment must be reasonably necessary and likely to prevent losses, no? Meaning the employer has already taken other measures, no? Like cutting other costs other than labor costs, such as reduction of bonuses, reducing time, or trimming down of expenses for marketing and advertising, including adopting of flexible work arrangement. In fact, the Department of Labor and Employment issued a labor advisory, no, taking into consideration that the retrenchment is a very drastic measure to be resorted to by the employers. That's why the DOLE came up with an advisory promoting the adoption of flexible work arrangement in order to do away with outright termination of employees. So second, so if there are losses which are already incurred, it must not be merely de minimis, or it must not be minimal. It must be substantial, serious, actual, and real. Or if it is only expected, it must be reasonably imminent, no? Meaning there must be a certain degree of urgency, which is objectively and perceived in good faith by the management. And the expected or actual losses, if there is already, it must be proven by sufficient and convincing evidence. So such proof may be shown through the submission of audited financial statements, low volume of sales, among others. Also, requirement is that it must be done in good faith, and the employer must use fair and reasonable criteria in ascertaining who among the employees should be terminated. In good faith, no, good faith is not limited to authorized causes. You must understand that good faith is the only limitation in the exercise of the management prerogative. So any actuation or any disciplinary measures undertaken by the management, if it is done in bad faith, it would render the acts of the management illegal. So it does not only apply to the authorized causes or retrenchment. It equally applies to all aspects of the exercise of management prerogative. It must be, if in good faith, it must be for the advancement of the legitimate business interest of the employer. It must not be merely resorted to defeat or circumvent the rights of security of tenure of the workers. Next, please. Also, the requirement, no, the 1 month notice to the workers concerned, as well as the DOLE before retrenchment or then downsizing is resorted to. Also, the employer must pay the retrenched employees separation pay, which is 1.5 month pay for every year of service or 1 month pay, whichever is higher. Next. So we now go to closure of business. No, it is also a ground for termination of employment unless the closing is for the purpose of circumventing the provisions of the labor code. There are also requisites in order for this to be used as a valid ground to dismiss or terminate the workers. There must be a decision to close or cease operation, and it must be done in good faith rather. And there is no other option available to the employer except to close or cease operations. Under this ground, because it would require the payment of separation pay, it must be distinguished, no? When the closure, of course, even if the closure is not due to serious business losses and the management would simply want to close for its own reasons, it is not precluded from doing so. And only provided that it would comply with the procedural due process, including the payment of a separation pay. But in case decided by the Supreme Court, if the closure is due to serious business losses, then the employer is not mandated to give separation pay to its employees. No, of course, the management, no, out of benevolence, they may also give financial assistance. But insofar as the law is concerned, they are not mandated. So unless, of course, there are existing CBA, they may also do so. Moreover, this closure or cessation of operation does not only cover kanang total closure. No? It is decided by the Supreme Court that partial closure is also falls within the coverage of this particular ground. So next, the employee suffering from disease, no? So if a particular employee is suffering from a disease and his continued employment is prohibited by law, or it is prejudicial to his health or that the health of his co-employees, and there is a certification by a competent public authority that the disease of such nature is incurable, no, within a period, or cannot be cured within a period of 6 months, even with medical treatment, and a notice is given to the employee, the employee may be terminated, provided that he shall be paid the amount equivalent to at least 1/2 month salary for every year of service, or 1 month salary, whichever is higher. So we now go to as I mentioned earlier, the just and authorized causes, it is through the initiative of the employer. While in this case, the employee is also given the right, to terminate his employment or to sever his ties with his employer, provided that he gives 1 month notice. Non-observance of the 1 month notice would render the employee liable for damages. Also, 1 month, the 1 month notice, prior notice may be dispensed with because there are also just causes to terminate the employee's termination through his initiative. First, serious insult by the employer or his representative on the honor and person of the employee. Also, inhuman and unbearable treatment accorded to the employee by the employer or his representative, as well as commission of a crime or offense by the employer or his representative against the person of the employee, and other causes analogous to the foregoing. So the employee need not comply with the 1 month prior notice. Also, there are also other instances, for example, sexual harassment. So sexual harassment, it is also it is considered as a crime or offense which may be committed by an employer against his employee. Also, when the employee submits a certificate of candidacy, his employment is automatically terminated. And since there's no dismissal, then the employee terminated is not entitled to the payment of separation pay. Next. So we now go to the principle on forced resignation or constructive dismissal. So constructive dismissal is actually a form of an illegal dismissal. No? However, it is not categorical on the part of the management that he is discharging or terminating the services of his employee. As defined by the Supreme Court, in a case, it is a quitting because continued employment is rendered impossible, unreasonable, or unlikely as an offer involving demotion in rank or a diminution in pay. So it is actually an involuntary resignation. No, it cannot be considered as voluntary because on the part of the employee, he is left with no other recourse but to terminate his employment because his employment is already unbearable. And because of this, it is a form or it is considered as an illegal dismissal. Now, as distinguished by the Supreme Court, there's a difference between illegal and constructive dismissal. So in illegal dismissal, it can be readily shown by the act of the employer in openly seeking the termination of an employee. On the other hand, constructive dismissal, it is a mere dismissal in disguise. So it is not readily indicated by any similar act of the employer that would expressly show its desire and intent to sever the employment relationship with his employee. So in illegal dismissal, in illegal dismissal, there is a categorical statement from the employer to terminate the employment, unlike in the constructive dismissal or forced resignation, because it can be deduced or inferred from the actuations of the management. So also, in some of the decided cases, the Supreme Court clarified the voluntariness, the procedure to determine the voluntariness of the employee's resignation. So the Supreme Court said that the intention to relinquish an office must concur with the overt act of relinquishment. So the act of the employee before and after the alleged resignation must be considered to determine whether in fact he or she intended to relinquish such employment. So if the employer introduces evidence purportedly executed by an employee as proof of voluntary resignation, then and it is vehemently or it was specifically denied by the employee, then the employer is burdened to prove the due execution and genuineness of such document. So now we proceed with due process. No, so the right of due process, it always goes with security of tenure. No, so the right of due process is a constitutionally guaranteed right. So it is a basic constitutional tenet that no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. Insofar as the Constitution is concerned, the employment, no, is considered as a property right. So it falls within the ambit of the due process of law under the Bill of Rights. So due process of law is basically defined as a procedure which hears before it condemns, or which proceeds upon inquiry and renders judgment only after trial. Now, next please. Now, due process has two aspects, no? The substantive aspect and the procedural aspect. The first discussion, the just and authorized causes, falls within the substantive aspect. So this basically refers to the validity or the legality of the basis of the termination of the employment. On the other hand, a procedural due process refers to the manner by which the dismissal or termination is effectuated by management. So, so these are the just causes I've discussed earlier. This refers to substantive due process. So, how to comply, no? Because procedural due process is very important in terminating an employee. For just causes, there must be a first written notice, no, which should contain the specific causes or grounds by which the management based its ground for termination, and of course a directive on the part of the employee to submit his or her explanation within a reasonable period. Next. So after service of notice, then the employers may schedule and conduct hearing or conference or some other fair, just, and reasonable way wherein the employees will be given ample opportunity, first, to explain and clarify their defenses to the charge level against them, as well as present evidence to support their defenses, and also to rebut the evidence presented against them by the management. But it must be noted, no, that the Supreme Court has already decided that actual or formal hearing is not actually necessary, unless, of course, it is specifically requested by the employee, in which case the management is mandated to give or conduct a formal hearing. Actually, the requirement of hearing is already complied as long as the employee is given ample opportunity to be heard and to defend himself. So that is the essence of due process, and it does not require a formal type of hearing. So the last notice, so after determining the termination that the grounds is justified, the employers will then serve the employees a written notice indicating that they have considered all the circumstances involving the charge level against the employee and the grounds by which they based or they justify the severance of employment. So basically, the procedural due process can be summed up to the so-called twin notice rule. No, the first notice informing the worker of the particular charges leveled against him, as well as giving him ample opportunity to present his evidence and to refute the charges by the management, and the last notice to inform the employee of the action of the management insofar as the grounds for termination are concerned. Now, with respect to authorized causes, it involves two, no? Um, the written notice, the 1 month prior written notice to be given to the DOLE and the concerned employees, as well as the payment of separation pay. So these are the procedural due process required before an employer may terminate an employee due to authorized causes. Next. So we go to also an important principle, no, in involving relative to termination of employment is preventive suspension. So preventive suspension is a disciplinary measure for protection of the company's property, pending investigation of any alleged reported violation. You must understand that preventive suspension cannot exceed 30 days. No, it may exceed, however, but the employee concerned must be reinstated under payroll. No, so he should be given his salaries, and it must be accompanied by written notice. But preventive suspension may only be resorted to, no, if continued employment of the employee concerned poses a serious and imminent threat to the life or property of the employer or his co-workers, and it is not actually a penalty. You must understand that if the employee has already been sanctioned for a penalty of suspension, the particular employee can no longer be punished anew for the same offense. That's why preventive suspension can be imposed even if it is not yet because it is not yet a penalty. So what are the remedies, no, or consequences of illegal dismissal? These are very important because the management would be rendered liable for its actuations if it fails to comply with the requirements of due process, the substantive as well as the procedural due process. So the remedy is first is back wages. No, the illegally dismissed employee is entitled to full back wages without diminution of his remuneration or benefits, and he must be reinstated, or if reinstatement is no longer feasible, he must be paid separation pay, but not the separation pay contemplated under just authorized causes, because this is 1 month pay for every years of service. And if there is non-compliance with nominal procedural due process for just causes, if the management fails to give a due notice to the particular employee, or in authorized causes, the management failed to give the 1 month notice to the DOLE or to the concerned employee, then nominal damages is accorded to the concerned employees. Now, there's a very important principle, no, or on the burden of proof in illegal dismissal cases, because you must understand the burden of proof lies or rests upon the employer to prove that the dismissal of the employee is valid or it is justified under the law. But however, before the employer is burdened to prove the validity of the dismissal, the employee concerned must first establish the fact of his dismissal. So when the employee cannot establish the fact of his dismissal, then there is no burden of proof on the part of the employer to prove, considering that there is no dismissal in the first place. No, so these are the references I used in this PowerPoint presentation. So that is all. Actually, the law on termination is very broad, no. In fact, in law school, it may take 1 sem, but it for the time, because of the time constraint, the presentation is merely to give or to discuss the salient features on the law on termination. So I believe that is all. Thank you everyone for listening, and good morning.
So thank you, Attorney Bajarla, for your presentation. Before we proceed to the open forum, let me first acknowledge our partners who are viewing now. For the Regional Tripartite Industrial Peace Council of Northern Mindanao, or the RTIP-CNM, viewing now are its officers and members led by Vice Chairperson for Labor, Mr. Nicandro L. Borja, and the Vice Chairperson for Management, Ms. Vivienne M. Lawansa. We also have the Northern Mindanao Federation of Family Welfare Committees, or the NMFFWC. Viewing now are the members and officers headed by the chairperson, Ms. Urchilin C. Basalio, and the vice chairperson, Mr. Jose Eric C. Baralea. So again, thank you everyone for actively viewing this webinar session. So just some stats for this morning. As of 10 o'clock a.m., we already have 328 registrants actively viewing through Zoom and more than 80 live FB viewers. Thank you again, everyone, for actively viewing. Now we proceed to our open forum. Our resource speaker is now ready to answer your queries. Participants may ask their questions through the chat box addressed to the chat box moderator. Kindly include your name and the name of your company. Reminding everyone to please keep your microphones on mute. Again, for those who have registered, please fill up the feedback form with the link provided in your chat box. Kindly fill out this form with your full name per your registration details, as this will be our basis for your name on the e-certificate of participation. The certificate will be emailed to you through the email address you provided upon registration to this webinar session. Your feedback will greatly help us improve our future webinar sessions. Now for our open forum, Attorney Bajarla. Our first question is,
So dini ko magtanaw, no? Dini ka camera.
what is the rule after the lapse of the temporary layoff of 6 months? What should the employer do? What is the right of the employee? Attorney?
So under the labor code, no? After the lapse of 6 months, the employees are already considered, they should be reinstated. Otherwise, they are considered as constructively dismissed. In order to evade the filing of charges for illegal dismissal, then the employer should give the employee the termination pay to which the employees are legally entitled to. No? Because the separation pay after the lapse of six months, it can be considered as the termination of employment is already permanent. So the employees are entitled to the payment of separation pay. And on the part of the the employees, they may demand for the payment of their respective separation pay.
Okay, Attorney. Another question from Cagayan de Oro. Security guards on reserve status who accept employment in other security agencies or employers before the end of the above 6-month period may not be given separation pay. Is this ruling still binding?
Yes, no? Because when this is tantamount, actually the actuation of the security guards is tantamount to resignation. So because it is a rule that resignation precludes the payment of separation pay if it is voluntarily done by the workers concerned. Since the security guards were not terminated, then there's no liability on the part of the management to pay separation pay.
Okay. Thank you, Attorney. So for the next question, still from Cagayan de Oro, is habitual absences of the employee a ground for termination of employment?
Yes, no. As held by the Supreme Court in numerous cases, habitual absences of the employee is a ground for termination of employment. However, you must understand that dismissal is should be the last resort. No, even if there is habitual absences committed by the employee, there are instances when the Supreme Court, instead of meeting the penalty of dismissal, they stated that a lesser punitive penalty should be meted against the employee, perhaps suspension, depending on the circumstances, because there may be instances where because of the loyalty of the particular employee or the reason for his absences is not what do you call this, there may be justification for his absences or her absences, then it may be that the lesser punitive penalty would be meted against the erring employee. However, there are decisions promulgated by the Supreme Court, no, upholding the valid termination of employment on the ground of habitual absences.
Okay. Next question. What are the procedural due processes for employees who are on a WOL status?
What is the
What are the procedural due process for employees who are on a WOL status?
The procedural due. So it is the same, no? The procedural due process, as I mentioned earlier, of course, katong three. There are actually three, but it can be summed up on the twin notice rule. First is the employee must be notified of his AUL, and that it, all the details of his AUL, and that it will be the basis for his termination, and the employee and that first notice is given ample opportunity to refute the charges level against him, in this case AUL, and the last notice is the termination letter. So the observance of which would render the dismissal, if there is a legal basis, as valid. So in any infraction, the two notice rule is very imperative. That's all. The first notice as well as the second notice.
Okay, attorney. Now for the next question, habitual absences of the employee due to sickness, is this a ground for termination from employment? Habitual.
Yeah, depende, no? Because as I've stated earlier, the particular employee who is suffering from a particular sickness or ailment, which if despite medical treatment, he cannot be cured within a period of 6 months, then it may be a ground for termination of employment. It is a recognized authorized cause, no? And if the absences, while it does not exceed 6 months, and if there is legal justification of the same, then the termination cannot be validly upheld, no? Because the habitual absences is not due to the fault of the employee. However, if the sickness of the employee renders him unable to discharge his functions, for example, then it may be a ground for termination, provided that a separation pay is given to the employee concerned.
Okay, attorney. Now for the next question. This is on resignation. What is the rule on resignation? Should resignation be in writing? And what are the requirements to consider an employee a WOL?
The rule in resignation, no? The rule in resignation is it must be voluntarily done by the employee, and it need not be in writing, because the resignation may be inferred from the particular acts of the employees. Like for example, a particular employee would no longer report for work. It is as if he is already under the employ of another company or establishment. Then that is already considered resignation, even if it is not done in writing. Now, what are the requirements to consider an employee on a WOL? Absences without leave. First, there must be unjustified failure of the employee to report for work, no? And despite repeated warnings, or despite repeated notice from the management to report for work, he fails to report for work. So that can be considered as AWOL.
Okay, attorney. Still on resignation, on the 30-day notice for resignation, when does the counting start? Is it when the letter was submitted, or is it when the employee verbally signified intention to resign? Also, do we consider verbal resignation?
When the letter was submitted. Now, the 30-day notice rule is counted from that time he intends to sever his employment relationship. So, for instance, the 1 month requirement, prior notice, is not when it was submitted, but because the notice, it may, although it can be in writing, it may also be verbally communicated to the employer, provided that the employer will accept the same. So that is the rule on the 30-day notice for resignation. As I mentioned earlier, verbal resignation can be considered if the employer will accept the same. However, if the employer demands that a written resignation be submitted, it should be done by the employee, because it is provided for under the labor code that 1 month written notice should be given to the employer. Otherwise, the employee would be liable for damages.
Okay, attorney. Now, on retrenchment, what are the requirements needed by law before an employer implements retrenchment? What are the proof or evidence needed to be presented? And what do you mean by substantial evidence?
What are the requirements? So before an employer can implement retrenchment, as I've stated earlier, it must comply with the procedural due process. No, first it must undertake to submit the 1 month notice to the employee concerned and the DOLE, and before retrenchment can be undertaken by the management must consider that it is a last resort. No, the retrenchment can only be done if all other measures have been implemented and undertaken by the management, such as cost-cutting measure, like, for example, in numerous cases, the cutting of bonuses, as well as the cutting of kanang advertising cost, among others. So what are the proof needed to be presented? So it depends, no? Because if retrenchment is to prevent losses by ruling of the Supreme Court, the employer did not present audited financial statement, considering that because of the measure undertaken, it could be that the losses have already been averted. So audited financial statement may not be necessary. But if the losses have already been incurred, then the employer should submit a financial statement, or for example, losses of clients, and all other records to show proof that indeed the retrenchment is not simulated. So what do you mean by substantial evidence? So substantial evidence is the quantum of proof, no, required in labor cases to establish a particular fact. No, in legal parlance, substantial evidence means such relevant evidence which a reasonable mind might consider as adequate to support a conclusion. So in the hierarchy of quantum of proof, it is lesser, because first there is proof beyond reasonable doubt, preponderance of clear and convincing evidence, preponderance of evidence, then substantial evidence.
Okay, attorney. Still connected to retrenchment, another question is how to compute separation pay due to retrenchment.
What is the computation for
how to compute separation pay due to retrenchment?
Computation pay, okay. It is already provided, no, under the labor code, that the computation must be 1/2 month pay for every years of service, or if he had of the employee already renders 1 year, then 1 month pay for every 1 month pay, whichever is higher.
Okay. Now on a retiring employee. A retiring employee is a retiring employee entitled to separation pay or retirement pay. What is the retirement age and how to compute the retirement pay? Is the 13-month pay equivalent to bonus, and how important is the pay slip? So this is from one.
First, a retiring employee, no, is entitled to retirement pay, of course, if he complies with the provisions on retirement pay law, which he must be at least 60, and he must have rendered, or she must have rendered at least 5 years of service. While although there are instances when the CBA provides for the age requirement to a lesser than 60, then if he complies, then he is entitled to retirement pay. However, the employee cannot be entitled to separation pay or retirement pay at the same time, no, unless of course there is favorable company policy or company practice, because separation pay is given to an employee if his employment is already severed, the same way as in retirement. So the employee cannot claim both separation pay and retirement pay unless there's a favorable company policy, or it has already the policy of the management has already ripened into a company practice.
Okay. Sige, from another view.
What is the computation for separation pay? It depends. If the cost of separation pay is falls within retrenchment or katong taas, no? Retrenchment, so 1.5 month pay for every year of service, or closure due to closure, while installation of saving device or redundancy, it is 1 month pay for every year of service, or 1 month pay, whichever. 1 month pay, no, 1 month pay of year of service. So what? If separation pay is due to an employee who is illegally dismissed, then the separation pay is considered as to be computed at 1 month pay for every years of service in illegal dismissal cases. So what is the retirement age? So the retirement age as provided for under retirement pay law is 60. This which is at the option of the employee. However, if it is at the option of the employer, it is 65. In addition, the age requirement may be subject to CBA provision. No? So the parties can agree as to what is the minimum age for retirement. So it is not limited to 60 or 65. So how to compute retirement pay? So the retirement pay is computed at 1.5 month pay for every year of service, but it is computed at 22.5 days because it already includes kanang 13-month pay as well as the service incentive leave pay. Is 13-month pay equivalent to bonus? 13-month pay is, it depends. If the 13-month pay is given to the employee or similar to a 13-month pay, then it may be do so. It may be considered as 13-month pay. But if there is a bonus given to an employee other than the 13-month pay, of course, the parties can agree on that. But basically, the 13-month pay, it is because it is different from a bonus because it is legally demandable. But if the bonus given already partakes the nature of 13-month pay, then the employee can no longer claim 13-month pay apart from the bonus, which is already equivalent to his or her 13-month pay. So how important is the pay slip? So under the labor code, the employer is required to keep records, 3 years, such as the payroll, and the pay slip is important in order to validate or to confirm whether indeed the particular employee or the particular management has been complying with the minimum standards set by law. So, for example, minimum wage or the contribution to the SSS, PhilHealth, and Pag-ibig. It may be used as evidence of the fact of non-compliance of the employer on his duty to pay the minimum labor standard benefits accorded to an employee.
Okay. So for the next question, attorney, there's a situation. The principal did not inform the agency concerning the absences of an agency worker. However, the principal, upon knowing of the absences of the agency worker, ended the employment. What is the correct way to discipline an agency worker?
No, the principal did not inform the agency concerning the evidence of the no, knowing of the employer ended the employment. The principal did not inform the agency concerning.
Yes, attorney. The principal did not inform the agency regarding the absences of an agency worker.
How come the principal, upon knowing of the absences, he's already? Maybe the question is, however, the agency. So basically, the principal, because of the absences of the worker, you must understand that the service agreement is subject to agreement between the parties. So, faithful non-compliance of the provisions therein may render the revocation or cancellation of the service agreement, depending on the agreement of the parties. So, if it was stipulated that the deployment of the agency workers in the principal, which would, of course, naturally prejudice the principal, then they may end the employment contract. How? Employment of the agency. Sorry, it is not employment. They are referring to the worker. Of course, the correct way to discipline an agency worker is through the agency, because you must understand that the disciplinary, the management prerogative to discipline pertains to the employer. No, in this case, if the employer would exercise the power of dismissal, then it may be taken to mean as he is the indirect employer of the agency worker. So in order to discipline an employee, the principal must strictly abide by the principle that the power to dismiss or discipline is lodged with the agency and not the principal. Of course, the principal can notify the agency in order that the agency would take the necessary or disciplinary action against the worker who has been recurring absences.
Okay. For the next question, how can an employee on a WOL be notified if his or her address is no longer traceable?
It can be sent through his last known address. No? So it would be considered a sufficient notice.
Okay. Sige. On the next question, attorney, what is the rule on preventive suspension? What if the investigation is not yet done after the 30-day period? What are the rights of the employee after the lapse of the 30-day preventive suspension period?
So the rule on preventive suspension requires that it must only be resorted to if there's an imminent or serious threat on the company or property of the employer. No, it cannot be indiscriminately used by the employer on all employees. And if the investigation is not yet done after the 30-day period, supposed to be, the law provides that he should be already reinstated. Or it can be physical reinstatement or reinstatement under a payroll. So wherein he does not or she does not physically report for work, but he or she is already entitled to his salaries. So after the lapse of the 30 days, so the worker has the right to be reinstated either on payroll or on physical reinstatement. But it is within the management prerogative on whether it is physical reinstatement or reinstatement on payroll.
Okay. So, attorney, for the next question, is it legally possible for an employee to request a floating status of more than 6 months rather than being terminated from employment?
Although any agreement of the parties, any stipulation, so long as it is not contrary to law or public policy, it may be considered valid. However, you must understand that floating status as provided for under the labor code cannot exceed 6 months. So basically, such agreement would run counter to the intent of the law that the floating status should not be more than 6 months.
Okay, that is noted. So next, is retrenchment and downsizing the same?
Well, retrenchment or downsizing, they are interrelated, no? Because retrenchment, the difference, the similarity is that retrenchment, downsizing, it involves the reduction of workforce, but retrenchment is a cost-cutting measure, while downsizing may not necessarily involve losses, no? For example, if there is redundancy, it can also be coined as downsizing. So you reduce your workforce, but not necessarily because of losses or impending losses. They are the same in a sense that they involve reduction of work, but it does not necessarily mean that downsizing is only retrenchment, because retrenchment requires losses, no? While downsizing can be undertaken even if no losses, such as in redundancy.
Okay. So for the next question, an employee was demoted from his present position by his employer without just cause, and he was replaced by another new employee as the choice of the employer. Is this demotion? What is demotion, and is it legal?
Demotion actually is a prerogative of the management, no? However, it involves a reduction of salary or perhaps the functions be performed. There is diminution in benefits also. It may be considered legal if it is undertaken in good faith and as a disciplinary measure, no? Because you must understand that it is the management prerogative to determine the appropriate penalty, where the management deems it best to demote the employee rather than outright terminate the employee, then it may be considered as legal. But demotion in the sense that it is used by the management for no apparent or justified reason, then it is basically illegal, and it may even constitute illegal constructive dismissal. And the management would be accountable, no, for illegal dismissal if such demotion is not undertaken in good faith and there are no justified reason for such action.
Okay. For the next question, if in this situation, attorney, if 30 days advance notice of an employee prior to termination of employment is not enough to do turnover of the employer, can an employer request to extend the employment of the employee until they can find a replacement?
It's 30 days. No, you must understand, if a person would resign, even if it's only 2 days, the employer cannot demand that he render, or the employee must render observe the 30-day notice requirement, because it would result to involuntary servitude, no? Involuntary servitude is prescribed under the labor code. So if the 30 days have already lapsed and there's no, the employer has not yet find a replacement, then the employer cannot demand that the employee would render service, unless of course if it is voluntarily agreed upon by the employee. But if it is at the instance of the employer and giving no option on the employer to refuse such request, then that is basically illegal, as it is a form of involuntary servitude.
Okay. Now, attorney, regarding breach of trust, particularly on theft, what if there is already solid evidence of the act? Up to what degree can we hold claims of a personnel, especially when the reported amount is a bit substantial? Do employers have the right to hold unpaid salary and other remuneration as part of the initial settlement?
Do employers have the right to hold unpaid salary and other remuneration? If there is settlement, then it can be subject to the agreement of the parties. So if the employee would agree that instead that his or her salary would be withheld, then it can be arranged, no? But if in your first case, up to what degree can we hold the claims of the personnel? If there is it is duly established that the employee has already committed an act of theft, for example, and there is already a finding, no, from a competent court, then basically the employee is already has a debt or is legally obliged to pay the employer. So it may be legal compensation or set-off may take place. However, if the theft, no, is not yet duly established, or there's no declaration from a competent court, so it is not yet due and demandable. So the legal compensation cannot take place. So the degree in which the employee can hold the claims of a personnel depends on whether there is already when there is a declaration by the competent court that the employee is already liable to pay or to reimburse the employer. But in the absence of such declaration, the employee cannot on its own initiative just withhold the salaries of the employee. Of course, they may file a case, no, in order to recover, but definitely they cannot withhold such unpaid salary and other benefits.
Okay. Next, in the event that the new employee who replaced the demoted employee resigned and the employer wished the demoted employee to be back to his previous position, what is the right of the demoted employee in this case? Naa ba siya'y right to accept the offer due to the hurt and pain that he underwent?
The right demoted. In the event that so basically, the demoted employee is at the dilemma whether to accept his previous position as offered by the employer. Of course, it is if it involves promotion, no, since he is already demoted, you must understand that promotion is it is dependent on the employee whether he or she accepts the same. So basically, if the employee refuses to accept such promotion, then he cannot be compelled to do so. But if the previous position merely involves a transfer, which you must understand is a management prerogative, then he must comply with the directive of the employer. But as I understand your problem, it would appear that since you have already been replaced and you're demoted, the position vacated by the new employee already is a promotion, and so you have the right to refuse the offer of the employer to be taken back to your previous position.
Okay, see, attorney. Another question. Our company president issued a memo on special retirement package last August 19, but interested employees are required to submit their application for retirement by August 30. Is this legal?
In August 19, but interested employees are required to... Yes, of course, because the special retirement package is not legally it's not legally demandable on the employer. So the special retirement package, of course, is subject to the conditions or the compliance of the conditions as set forth by the company president. Unless, of course, the said retirement package would refer to katong age of 60 or 65, which the conditions cannot supersede the retirement pay law. So in this case, if it is not if it is voluntary on the part of the company, then they may impose conditions, certain conditions or terms, including the submission of application for retirement on August 30. It is legal in the sense that it is not prohibited by law, so such stipulation may be, or such terms may be incorporated or may be used by the employer in order to avail of the special retirement package. Because the condition is not illegal or nor is it against public policy.
Okay, attorney, is furlough and forced leave the same? And is it referring to temporary closure of unit or department or just selected employees in that unit?
Furlough or forced leave the same. They are not the same in the sense that furlough is it can be considered as infraction, no? The employee, particular employee who commits the same may be disciplined, no? Unlike in forced leave, where the employee, if it is allowed by the management, they are given leave credit or forced leave, then it can be legally undertaken by the employees. In contrast with furlough, where the employee can be subject to disciplinary action. And is it referring to temporary closure? And is it referring to temporary closure?
Okay, okay, attorney, for the next question. In this situation, attorney, what if galing siya ng floating status? Then for back to work na siya, pero hindi na isyuhan ng back to work kasi may previous case siya sa agency na hindi pa nasasagot. Na-follow naman po ang twin notice. Is this considered constructive or illegal dismissal?
Floating status, then for back to work na siya, pero hindi na isyuhan ng back to work. Maski kasi may No, what constitutes constructive illegal in this case is not the observance of twin notice, no, but the fact that after the floating status, he was not allowed to report to work. So basically, as mandated under the labor code, after the end of the floating status, the employer is legally mandated to reinstate or to recall the worker under floating status. But in this case, because of his previous case, he was not recalled. So it is tantamount to illegal constructive dismissal, regardless of the observance of twin notice rule. Because as I've stated earlier, due process is twofold. One is substantive and procedural. While you complied with the procedural due process with the twin notice, however, the substantive due process, you failed to comply, since after the lapse of the floating status, you failed to recall or to reinstate the employee, and it is also tantamount to illegal constructive dismissal.
Okay, attorney. The next question. He has not yet been informed to go back to work, even if he is not a PUI or close contact employee. And it has been 6 months already that he is not been informed to go back to work. Is it possible that he is already terminated from employment even if no letter of notice has been given to him?
As I've stated earlier, no, after the last lapse of 6 months, the employees must be reinstated or recalled to report back for work. However, you must understand that in these trying times, because of the COVID, you cannot expect, no, perhaps there was a notice given, but the courier service failed to deliver the same to your residents. The more prudent thing to do is you should inquire first to your company whether the company is still willing to reinstate you or recall you, because that is the only way by which you can determine whether indeed there is no intention on the part of the employer to recall you to report for work. While you have not received a letter of notice, it does not necessarily mean that the management would no longer reinstate you to your work, no. So it is best that you inquire first to your company, and if you already determine, if you already aware that there's no intention on the part of the employer to recall you, then you may already consider yourself as terminated. And of course, the consequences of termination, illegal termination, is the corresponding penalty due to you by operation of law.
Okay. So, attorney, due to time constraints, this will be our last question for this morning. What is the difference of 6 months floating status against 3 months floating status? To what industries does this apply?
So the 6 months floating status, no, it applies not only under Article 301, katong temporary suspension of operation, bona fide suspension of operation. It also applies to employees under agencies, no, or service agreements. It is provided for under DO-174. While 3 months rather, while the 6 months of floating status apply to security guards. Basically, the 3 months floating status as contemplated under DO-174 encompasses those employees under agency or under contractors, with the exception of the security guards. While they are under agency, there is policy instruction 20, or but it refers to the floating status of security guards, which can go as much up to 6 months, no. So that is basically the difference.
Okay, attorney, thank you very much. So that was our last question for this webinar session. We would like to thank everyone for actively participating. We would also like to thank our resource speaker, Attorney Bajarla, for accommodating the questions of our participants. As mentioned earlier, after this session, we still have 4 more sessions to go for Series 2. The schedule of the sessions can be found on our Facebook page, the DOLE-X Labor and Employment Education Services -LEES. And for faster searching, you may also search at DOLE-X LEES or DOLE-X LEES on Facebook. We also invite everyone to visit and like the DOLE Bureau of Relations Facebook page through www.facebook.com Bureau of Labor Relations PH. The DOLE BLR is headed by Director Maria Consuelo S. Bacay. Now at this point, we would like to thank RCMB10 and their director, Attorney Ligaya R. Lumbay, for providing Zoom access during this session and to all upcoming sessions for the DOLE-10 Convergence of Programs webinar series. We look forward to having all of you again next Friday and of course the succeeding Fridays in October. So please keep posted for updates on this through Facebook and the official DOLE-10 website. Again, this is Justine Ongchua Kamugao, and may you all have a pleasant weekend ahead. Take care, everyone, and stay safe.
Thank you, ma'am.
Thank you.
Thank you.
Enjoy.
Tayo'y magkaisa.
Salamat.
Sa diwa at gawa. Laging higit sa isip itong ating bansa. Laging higit sa isip itong ating bansa.
Shout out Mr. Clean Albaracin. Director sa Pepsi.
Thank you.